So, at MF Furatama, what we are going to discuss is the forms of business organization and the effects of incorporation of a business entity. So, under the Business Registration Act of Maldives, there's a requirement that for each person who wants to conduct a business in the Maldives should register their business entity in one of the following forms. So, it needs to either be a company which is registered under the Companies Act, it can be a partnership registered under the Partnerships Act, and it could be a cooperative society registered under the Cooperative Societies Act, or lastly, it could be a sole proprietorship registered under the Sole Proprietorship Act. The legal obligation or the responsibility to register is identified in the Business Registration Act. So as I just identified, there are generally four types of entities or four types of business organizations that are recognized under the relevant laws of Maldives, which are sole proprietorships, partnerships, companies, and cooperative society. If everyone could mute their mic so I hear some background noises, so just would be helpful. Thank you. Okay, thank you, everyone. So for sole, I will just touch upon sole proprietorships first. So a sole proprietorship is a one-person operation. So there's generally a single individual who will carry out a sole proprietorship. So as a general, I'll just touch upon the general, general characteristics of a sole proprietorship, and then I will touch upon what is provided in the Sole Proprietorship Act. So generally, it's a one-person operation, and the profits of such sole proprietorship that is received is solely owned and enjoyed by this one person, because sole proprietor is that one person. So all the profits are enjoyed by this one person. Contracts are entered in their own name, and all liability and debts are also personal. Raising of capital in the sense of the money and the resources that are obtained for the running of the entity is also solely conducted. Such capital is usually provided by the sole proprietor out of his personal savings or through a bank loan that the sole proprietor obtains. So a sole proprietorship has a higher operative risk because the sole proprietor himself is responsible for any liabilities and debts of the sole proprietorship. There's no difference between a sole trader's personal and business assets. Creditors, so any creditors to whom the sole proprietor owes money can go after the trader's personal assets, for instance, his home, car, any other personal assets to recover their debt. So for instance, for a company, the company's assets are deemed assets of the company, and in a case where there's a debt by the company, um, creditors who the company owe money to cannot go after the assets of the shareholders themselves. But in the case of sole proprietorships, what happens is that um, the debtors or the creditors can go after personal assets such as the sole proprietor's home, car, or any other assets which belong to the sole proprietor. So under the Sole Proprietorship Act, it also recognizes the characteristics that I just mentioned. For instance, the Sole Proprietorship Act specifically provides that the capital should be raised by the proprietor himself. All assets of the entity are owned by the sole proprietor himself as well, and all profits belong to the sole proprietor himself. All losses and all debts are also borne by the sole proprietor himself. The sole proprietor should be responsible for all matters of operation and all transactions entered by the entity. So that is recognized specifically in the in the Sole Proprietorship Act. Slight benefits of sole proprietorships is that there's no risk of disagreement because he is the sole person who is running the entity. So there's no disagreement in the case, for instance, if there are shareholders and directors of a company, there may be disagreement because there are more people to provide their opinions. But in the case of sole proprietorship, it's just that one individual who is carrying out this business, and therefore um, there's no risk of disagreement. There, once again, there's no need for formal organizational structure as well, and this is usually adequate for a single person with capital, but not suitable for a large-scale investment. Um, I've seen that in the syllabus, it also requires you to know slightly about the registration process. So I've just provided a slight brief of how you can carry out registration of the sole proprietorships. So according to the Sole Proprietorship Act and the relevant regulation, it's a very simple registration process which you have to apply through the Ministry of Economic Development. And what is required is basically the copy of national identity card of the owner, who should be a Moldavian citizen. So a sole proprietorship cannot be registered under the name of a foreigner. It has to be a Moldavian citizen, and so subsequently you just need the consent letter for the person responsible for tax, which will usually once again be the sole proprietor himself. And for termination or for deregistration of a sole proprietor, the sole proprietor can decide that he no longer wants to carry out this business. He can determine as such, and within 14 days of deciding that he no longer wishes to continue or commence or continue with this business, and that this business has been concluded, he just needs to um, register the a notice within 14 days of deciding that. um, so it's just from the so it should be upon filing a notice at Ministry of Economic Development within sorry, within 14 days from the date of conclusion of business of the sole proprietor. So it just needs to be a notice to the Ministry of Economic Development that I have just decided not to continue with the business, and therefore to deregister this. The ministry has the option to further, further look at the documentation. Sorry, I'm just getting some background noise, so if you could all mute. Okay, that's fine. Thank you. Um, so the ministry has the option to further see how the sole proprietor has concluded its business, and upon filing the notice for discontinuation or deregistration within a month, the Ministry of Economic Development shall decide that this sole proprietorship has been cancelled or terminated. Even so the Sole Proprietorship Act further recognizes that even if a sole proprietorship is cancelled or deregistered pursuant to the Sole Proprietorship Act, the sole proprietor can still remain liable for the operations or transactions it has conducted while it was in existence. So, for instance, say at the end of the year, a sole proprietorship was terminated or cancelled, but it could still be liable for it could still be, it could still be liable for the operations or transactions that it has conducted while it was in existence. It could also be um, liable for any debts or any other obligations which arose at the time of it being in existence. So generally, that is a brief of how sole proprietorships run and the characteristics of a sole proprietorship registered in Maldives. If there are any questions on specifically sole proprietorships, please proceed to ask. Okay.
Kan
So
kita
we
so
will. Okay, Kato.
aun suale pe mihar mi
Ade.
amal kuramunda konfonya be gano me kedashon eme farata ga sebo konfoni bo fedde ehem vejja me halatoga mi sole proprietor ke hama mi furima wanje kanta to furima wanje heni
Companies with one shareholder ki tafatu ane entity engeta ega meharo ega innane we will go on to discuss that, but ega innane separate legal personality, which means the shareholder and the company is distinct and is run separately. In the case of sole proprietorships, it is mostly like personal businesses that are registered as sole proprietorships, and in this instance, there's no separate legal personality because they can go after the sole proprietor's personal assets. In the case of a single shareholder company, um, they cannot go after the shareholders' assets. So, uh, forming a company provides better protection to the shareholder themselves. But it also comes with further, further obligations under the Companies Act for instance, running or appointing a board of directors and all of those uh, uh, administrative processes need to be completed. But in the case of sole proprietorships, then it's a simpler process in terms of running, but the risk of operation is higher. So I will just move on to partnerships. So a partnership is a form of entity which is formed as per the partnership agreement. Um, in the jurisdiction that we follow in England and Wales, this partnership agreement could be in the form of an oral agreement, or it could be written, or it could also be inferred by conduct. But in the case of Maldives, the partnership agreement would need to be in writing for the purpose of registration. So, under the Partnerships Act of Maldives, partnership has to contain at least two members, and the maximum number of members it could have is 20. There's a flexible organizational structure in this as well, because partners can decide how the partnership is run through the partnership agreement. So, whatever is written in the partnership agreement and agreed between all the partners is how the partnership will be run. Once again, there's uh, partnership can sue or be sued. There's legal recognition that this partnership is a separate entity, so it can sue and be sued. It can also enter into legal relations with anybody it wants to enter dealings with. And just some characteristics of partnerships include, for instance, partners are joint and severally liable for all debts and other liabilities of the partnership during the time they are partners of the partnership. Even if the partner exits the partnership, for instance, let's say a partner exits in the year 2025, but he has been a partner in the year 2024. Even if he leaves in the year 2025, he is still liable for any actions which were undertaken in the year 2024, that was before he left. So he will still be joint and severally liable for any debts and other liabilities for the period he was a partner. However, a partner shall not. This is recognized under the Partnership Act. A partner shall not be liable for things done by the partnership before the partnership uh, partnership's admission. So if at all the partnership has carried out any actions before the partner has joined, the new partner cannot be made liable for those previous actions of the partnership. Similarly, where a partner has extended the partnership's money for a purpose other than those of the partnership without permission from the other partners, then such expenditure shall be a liability of the partner who actually gave that money, and the liability shall not fall on other partners. So, in terms of registration of a partnership, once again, it's a simple process where um, there should be a partnership agreement in writing. Um, then it should be national ID card of the partners must be submitted. The tax responsible person must be determined and informed through the tax responsible person information form, and there should be a managing partner, which shall be decided by all the partners. It will be reflected in the partnership agreement, and therefore there should be a managing partner's declaration where he says he's responsible for the partnership and he accepts the position of managing partner. And if a partner is, for instance, an entity, then in that case a resolution of that entity who is going to be a partner is also required. Then a partnership can subsequently be dissolved or um, terminated by a resolution of the partner stating that uh, this partnership is now dissolved or liquidated. So now we'll look at a company. A company has limited liability. Limited liability in the sense of the um, company is separate from its members, and company is only responsible for the transactions that it conducts. It has the it is it is legally recognized, and therefore it could sue and be sued, can enter into legal relations. For the formation of a company, the company would have to adopt articles of association and memorandum of association. The articles of association is essentially in addition to the administrative requirements imposed under the Companies Act. The it the articles of association is a document which kind of where all the shareholders of the company agree that this is how the company must be run, and the memorandum of association indicates the shareholding structure, share capital, and the purpose of the company. As I just mentioned, articles of association contain the internal rules of the company and objects clause limiting the power a company may have. And the memorandum of association contains the company's name, share capital. It's like basically the birth certificate of the company, where it just indicates the company name, share capital, address of the registered office, the type of company, the liability of members, statement of company directors' names and addresses. So basically, it's like a snapshot of what the company is going to do and what the company is, the relevant information of the company. But separately, the articles of association of a company is the internal rules of the company agreed by the shareholders, and that is how the company shall be run unless the shareholders decide otherwise. For registration of a company, um, the documents required would be the articles of association and memorandum of association, which are signed by the shareholders of the company. There must be a managing director of the company, so the managing director's declaration is also required. The company secretary's declaration is also required. Company secretary is someone who ensures that the company is run in accordance with the Companies Act and ensures the obligations of the company under the Companies Act are adequately adequately satisfied. Um, the fourth document would be the tax responsible person information form. Once again, there must be someone who is appointed for as the person responsible for tax, and that person will have to kind of his information would have to be submitted to the Ministry of Economic Development. Then the obviously the national identity card of the shareholders, directors, managing director, company secretary, tax responsible person, and authorized signatories must be submitted along with the application. If at all the company's shareholders are going to be another company, then you would require a board resolution of that company, that shareholding company, to also be submitted. Such shareholding share that such board resolution of the shareholding entity shall include that they are willing to kind of acquire shares in this new company, and that this is the amount of shareholding percentage that they will hold, and the details of representative directors on the board of directors. Then the fourth type is cooperative society. Cooperative society is actually kind of like a voluntary association where any person is free to join or leave. The primary objective is not to earn profit, but rather provide kind of voluntary support, um, economically, socially, that the members decide. But it's a legal entity as well, so it can sue or be sued, and it can also have its own assets. So as per the Cooperative Society Act, a society must be an autonomous association of persons united voluntarily to meet the common economic, social, and cultural needs and aspirations. Such a corporate society must be run by the members through a democratic process. So, at the time, they will elect elect the. I'm so sorry. Just give me 2 minutes. Hi all, sorry, the fire alarm in my office went off, so I had to wait for a bit. Okay, so where was I? Okay, so a corporate or society must be an autonomous association of persons united voluntarily to meet their common economic, social, and cultural needs and aspirations, and must be run by members through a democratic process. So the members kind of elect a steering committee, and they will make the decisions of the company, but usually it's run through, it's done through a vote of the members. So in terms of registration, there must be a bylaw of the cooperative society. So the bylaws would basically determine that this is how the company will be run. The memorandum of cooperative society also must be submitted, a business plan and financial plan. Financial plan should include how they are going to obtain funding for the running of their operations. List of names of steering committee members. So, steering committee members at the time of registration, um, it could be the same members who are elected by the members, but at the time of registration, you'll just indicate that these are the steering committee members. And once again, for the purposes of tax, there must be a tax responsible person information form. Um, so in terms of the four types of business organizations that we just discussed, you can just have a look at the Companies Act uh, of 2023, Companies Act of 1996. So you can just just see some differences between the Companies Act of 1996 and Companies Act of 2023, which we will kind of touch upon before we end this lecture. You can take a look at the partnership. This should be there. You can touch upon the Partnership Act of 2011, the Business Registration Act, and the two other acts that are not included in this list is the Cooperative Society Act and the Sole Proprietorship Act. So, if those actually just indicate very administrative obligations and legal rights that are conferred by these acts. But if you have a look at these, it would be helpful for your bar exam. So the next topic I will just discuss is the concept of separate legal personality. So the concept of separate legal personality is that upon formation of a company, the company will be deemed a separate legal entity. Separate legal entity or separate legal personality is that a company is capable of potentially suing and being sued in its own name, of holding property in its own name, and logically, therefore, of making profits and losses that are not its own and not those of its members. So basically, the members or shareholders of the company are distinct from the company itself. The company itself has the power to sue and be sued or hold in property and carry out business on its own in its own name. Can someone explain to me what happened in Salomon versus Salomon, or the principle that was determined in Salomon versus Salomon? I'm sure you all know. You all know the principle that was established in Salomon versus Salomon. So I will just very briefly just touch upon uh, the case itself. It is a case where the separate legal personality principle was established. Um, in this case, Mr. Salomon, who was a shoe manufacturer, formed his own company, and um, the company ran into difficulties, and the company obtained a loan from Mr. Edmund Brodripp. The company went into more financial difficulty and was unable to pay its debt, and Mr. Brodripp went against Mr. Salomon's personal liability. So Mr. Edmund went against went to because it was the company was being liquidated. He wanted to go against and claim for Mr. Salomon's personal assets. In the High Court, Mr. Salmon was held liable, and his but at the point of appeal, the House of Lords decided that Mr. Salomon cannot be, the company cannot be deprived of its separate legal personality because Mr. Salomon is a shareholder himself. He cannot be held personally liable for the financial difficulties and subsequent liquidation of the company. And if the company is unable to kind of pay its debts at the time of liquidation, then Mr. Salomon should not be made personally liable. So this Salomon versus Salomon case is a landmark case that set up the principle of separate legal personality and laid the foundation for present day business, where An organization is independent of its shareholders, and this does it is deemed that this separation of the company and its shareholders creates a corporate veil, shielding shareholders from the company's money and liabilities. So, such a separate legal personality is recognized in the Maldives as well. It is recognized under the Companies Act, um, and it is also recognized in these case law that I have mentioned here. So, in the case of Muhammad Shavid versus Muhammad Latheef, it was held that after registration of a company, the company is a separate legal entity which has separate rights, assets, employees, transaction debts, and profits, and that the shareholder cannot be made liable. Similar principles were also upheld in the case of Muhammad Aslam versus State and Ahmad Aidani's Maldives versus GX Associates. So I think these might be in your reading list, so if you could take a look. But generally, the principle is that separate legal entity applies, then the shareholders of the company is a separate legal entity which has separate rights, assets, employees, transactions, debts, and profits, and the shareholders are distinct from the company itself. So the corporate veil is an idea that shields shareholders from personal liability for the company's actions and duties. So some key traits of corporate veil include limited liability. Um, so in the event of economic difficulties or legal troubles, shareholders are not answerable for the company's money owed beyond the amounts invested in the shares. Also, another key trait of corporate wealth is legal independence. So it means that once a company is legally incorporated, it is recognized as an impartial legal entity. It allows the company to enter into contracts, have personal property, be sued, sue or be sued, and participate in even in criminal acts on its call, but not having the shareholders liable for this. So it's any criminal act which the company commits is separate from its members as well. It's perpetual in existence, which means that even if the shareholders change, the company still remains. Uh, Separation of ownership and control. So, the separation of possession and control is that the shareholders do not typically run the company, and it can delegate the day to day control of and decision making to the board of directors of the company. But there are also instances where this corporate veil can be lifted. Um, this is because sometimes companies use this corporate veil to kind of commit um, abuse. And when so to hold the company and its officers accountable, the corporate veil can be lifted. Some conditions in which court would possibly apply the exception of veil piercing are as follows: fraud or wrongdoing. If the company is used to perpetrate fraud, conceal unlawful sports, or interact in wrongdoing, the court can pierce the corporate veil to hold the individuals who did that accountable. So usually it would be the directors. Evasion of legal obligations. When a corporation is mounted or operated to intentionally keep away from legal obligations, the court may disregard the corporate veil to prevent injustice. Alter ego or agency. If a business enterprise is deemed an alter ego or mere agent of its proprietors and not using the real separate identification, the court may pierce the corporate veil. Undercapitalization and unfairness or injustice is also another reason why the court can pierce the pierce the corporate veil. So in Maldives, we have had instances where the corporate veil has been lifted. So, for example, In the case of Mohammed Rashid versus Thiru Construction and Contracting Company Limited, the civil court referred to Section 74 of the Companies Act and determined that the company could not prove how amounts claimed for uh, by the claimant were spent, and therefore they were using the company as a shield to kind of get away from paying this. On this basis, the three directors of the company were ordered to pay Mr. Mohammed Rashid, and it's deemed that the corporate veil was lifted. Similarly, in the case of Sharulon Service Private Limited versus Fenaka Corporation Limited, judgment of the Supreme Court confirmed the circumstances where corporate veil of a company can be lifted to have directors of the company liable for actions undertaken by the company. The Supreme Court also further clarified that depending on the surrounding circumstances of the case, the corporate veil can be lifted, and the court can also deem the controlling persons of a company and the parent company, which is the shareholding company, for instance, of a subsidiary, liable as well. So the previous uh, the previous Companies Act, if we look at the previous Companies Act, Section 74 is the relevant section under which the corporate veil was lifted by the courts up until beginning of this year. So, Section 74 of the Companies Act indicate that. So it says, ಕುಂಫುಣಿಗೆ ಶಹಸಿಯತನ ಹಮಗೊತುಗ ಬೇಣು ಕೊಡು. So mi ಕಾನೂನುಗೆ ಫಂಡರ್ವನ ಮಾದಾಗ ಬಯಕೊಫಾವಾ ಗೊತುಗ ಮತ್ತಿನ್ ಕುಂಫುಣ್ಯ registry woman e ಕುಂಫುಣ್ಯ ki memberu na wakin ufedifawa. So that whole point is that the recognition that the company is a separate legal personality. So ಕುಂಫುಣ್ಯ registry woman e ಕುಂಫುಣ್ಯ ki memberu na wakin ufedifawa adi qanuni gotun amilla shakhsiyata libigenwa farataka veenamaves. Furatama baga mibunani mi kuvunyaki separate legal entity eke. Then devana baga mibunani thiriga bayankofawa halettakuga niwafa iggandege gotuka. So basically what they're saying is you're using the corporate veil to kind of shield yourself. එහෙම වීම එගොතුගා ඒ ශහසියතු බේනුම් ඉෆමු ගෙන්දිය කුම්ෆුනිගේ ඩිරෙක්ටරු කුම්ෆුන්යගෙන් නමුගා කුරි කන්තත්තක ඒ ඩිරෙක්ටරු අමිල්ලය ಜಿಮ್ಮ ಅಫುಲುಮ අමුරු කුරුමුගේ බාරු කෝටල් දෙබිගෙන්වේ මේ Section 74 ಗೆ දශුන් මෙබුණනි ඩිරෙක්ටරුන් personally liable කුරෙවිධානයේ කුම්ෆුන්යකුන් මේ corporate veil නහම ගොතුග shield ගොත බේනුම් කොග්ගෙන් mi hinga kankama ekama ko mi sharu launch masalaga mi decide ko fa mewani kumfuni ge komen director ona nuyas kumfuni hinguma mi ayanu kore fa controlling persons of the company nuata kumfuni ge parent company if it's a shareholder nuniya parent company ಗೆ ಸಬ್ಸಿಡರಿයෙන් ಹಿಂಗುಮ ಕಂಟ್ರೋಲ್ ಕುರಾಣಮ ಎಹಿಂದುವೆಸ್ ಮೀ corporate bail lift ಕುರೆವಿದಾಣೆ එහෙම me corporate bail lift ko me efaratave zimma kore. So it's not just limited to directors of the company anymore under sharu launch case. Then section 74 ga mibunani kum me annanive halettakuga me directorun amele zimma afuluma amuru kurumuge baaru kota libigame. So kumfunya libifava shahsiyatu qanuna ay khilafu kame kurumattaka beenu koffin. In kumfunya libifava qanuni shahsiyatu makara hilan hedumattaka beenu koffinama. Nuata kumfunya libifava shahsiyatu kumfunya darani du koffava faratakasha kumfunya ko viafari kuramun genda farataka oluwalumuge niyatuka beenu koffinama. މިމާއްދާގެ ހާ ޝަވިޔަނި ނޫނު ގާ ބުނެފައިވާ ހައިލެތަކުގެ އިތުރަ ގާނުނުގަ ބަޔަންކޮށްފައިވާ އެހެނިހެން ހާލެތަކުގަ ސೋ ކުންފުންޏަކުން މަކަރާހިލައިން ހެދުމަށް ކުންފުނީގެ ޝަޚްޞިޔަތު ބޭނުންކުރާނަމަ ނުވަތަ ގާނޫނާ ހިލާފު ކަމެއް ކުރުމަށް ބޭނުންކުރާނަމަ ނަތު ކުންފުނީގެ ދާރަނި ދޫކޮށްފައި ފަރާތަކަށަ ކުންފުންޏާކު ވިޔަފާރި ނުވަތަ ކުރަމުން ގެންދާ ފަރާތަކަށް އޮޅުވާލުމުގެ ނިޔަތުގަ ބޭނުންކު So there's always an element of fraud or misrepresentation where the corporate veil can be lifted. So me Kurim, what we highlighted, fraud or wrongdoing is there, evasion of legal obligations is there. Then courts have also gone on to say unfairness or injustice can also be a circumstance where corporate veil of a company can be lifted. So me Kudi Companies Act 1996 ke dashun kumfunya ke corporate veil lift kurevene haletta. Then miharuge gaanonu wada kumfunya behe gaanonuge gaanonu nidi aharumi um, implement kuri gaanona balalana. I will just touch upon that before I go. So the relevant provision corporate veil lift kuraminani section 65. Then kumfunige shahsiyata behe gotun hamawaki me section innan me kumfunya behe kaanonuga. I'll just open the act now so you can have a look. Whatever preference feneto miharu gano naran project kolla fenan angaldi.
Fene NMS liefing itching gave over a kudi ingato fenade.
Miharu kenatawani. Aran kiyala dena erathing aran zoom in call laughing godako. So me section 61 in and 65 aki mi kama gulong hori sections. Mega menani kufuni mega topic ki kufuni ge kanuni shasiyatna hamagotu ka peno koro. Then mi ganonu ge mi fulatama me fashion kufuni hingumu gana hama kumfuni hingumu gana hamagotu ka paru foro. Kumfunige faratun kura kama kanuwata dookolla kamaka golle gotun annanivi halataga kotu amaraka idevidane. Mika miburani kumfunige kala nahamugotuga kumfuni hingafi nama kotu amarakan edeveneka me section ga mi recognize kurani. Then mi halatagi kumfuning amal kura gotuge sababun jumla gotega memberunge maslahatan uni kamal lebu nuwata memberaka nuwata memberunnan e haysiyatu nuwata enun haysiyataku namaves ಅಣಿಯಾವೆರಿ ಅದು ಎಫರಾತಗು ಹಗ್ಗಂ ಹೀನರು ಕಮೆ ಅತ್ವೆದಾಣೆ ಫದ ನುವತ ತಫಾತು ಕುರುಂ ಏಗ ಹಿಮೆಣೆ ಫದ ಕೊತಕ ಕುಂಫುಣಿಂ ಅಮಲ್ ಕೊರ ಹಾಲತ್ತಗುಗ ಸೊ ಮಿ ಸೆಕ್ಷನ್ ಗ ಮೇ ಅಸು ಬೊಡ ಕುಂಫುಣಿ ನಹಮಗೊತುಗ ಕುರಾ ಕಮೆಗೆ ಸಬಬುಂ ಕುಂಫುಣಿಗೆ ಮೆಂಬರುಂಗೆ ಮಸ್ಲಾಹತ ಉಣಿ ಕಮೆಂ ಅಣ್ಣ ಹಾಲತೆ ಮೆದುವೆರಿ ಹಾಲೆತ್ತ ಮೀಗ ಮೇ ರೆಕಗ್ನೈಸ್ ಕುರಣಿ ಮಿ ಮಾತಾಗೆ ಹಾಗ ಬಯಂ ಕುರಾ ಕುಂಫುಣಿಗೆ ಫರಾತಂ ಕುರಾ ಕೊಮ್ಮೆ faratun kura kamen nuwata nuko dukolla kame denegатumuga annane kankama koton riak kuramane kumfuni hingagoy kumfunige faratun koffawa nuwata kuran hushala fawa kame nuwata kumfunige faratun nuko dukolla fawa nuwata nuko dukollama hushala fawa kame nuwata kumfunige memberunge tere waki klaheke bayaku fast koffawa nuwata fast kuran hushala fawa garar so mi kankama koton riak ko kuravidane දැන් මේ බයංකොරනි මිකානෝනගේ මේ ෆසල්ස් එවන මාදාගේ දශුන් කුම්ෆුඤ්ඤක ගොලගොත අනනේ ෆරාතක කෝටෝමරක එදෙවෙන කුම්ෆුනින් කුරා කුරි කමෙන් වතනු කොද්දු කොලි කමකා ගොලිගේ අන්නනේ හයිසියත කුම්ෆුනිගේ ಮೆಂಬರು ಕಮುಗೆ ಹೈಸಿಯತು ನುವತ ಎಹೆಣಿಹೆන් ಹೈಸಿಯತಕು ಕೋಟ ಅಮರಕ ಎದೆವಿದಾಣ ನುವತ ಮೆಂಬರು ಕಮುಗೆ ಹೈಸಿಯತು ವೆಸ್ ಕೋಟ ಅಮರಕ ಎದೆವಿದಾಣ so mi ಮಾದಾತಗಿ ಕುಂಫುಣಿಗೆ ಮೆಂಬರಕು mi ಕುಂಫುಣಿ ಹಿಂಗಾ ಗೊತ್ತುಗೆ ಸಬಬುಂ ಕುಂಫುಣಿಗೆ ಮೆಂಬರುಗೆ ಮಸ್ಲಹತ mi ಅಸಲು ಕೊಫವ ಹಾಲತೆಗ್ಗ mi ಫಸ್ತೊಳಸೆಕೆ ಫಸ್ತೊಳಸ್ತೆ den ಫಸ್ತೊಳಸ್ತಿನೆ mi ಅನ್ನಣಿ den ಫಹು ಕುಂಫುಣಿಗೆ corporate ವೇಲನೆಗು ಮೀನಣಿ ಫಸ್ತೊಳಸ್ ಫಹೆಗ್ಗ ege mi section ga mi bunani mi maddaga shawiyani ga buna gotuga mati mi ganunuga dashun registry koffawa kunfunya makara hilatun amale hingafenama nuwata kunfunige director nuwata member nuwata officer amilla manfaye ekani kunfuni beno kofinama kunfunige corporate veil kota karnegidani adi e halatuga kunfunyaki waki ganuni shakhsiyate kamuga weenamaves efadan amal kura kunfunige director nuwata member nuwata officer e kunfunyege namuga kuri kangama farudi gotun zimma ufulanche hene ehma kurige ganunuga minnani waraboda limit koffa kunfunige directorunne zimma kureveni mi kunfunige kanuni shahsiyatu na hamugotuga benun kofinama dekamaku mi eaffahu sharu launch case geba decide kure kunfuni ge parent company en wata kunfuni ge controlling person naka ves mi zimma ufulumang amru kure vidani එහෙම ඒ බේසිස්ක මේ kunfunya behe ganun ayro me eba recognize kure mi kunfunige corporate wel negene halattakuga mi kunfunya ki waki kanun shahsiyate kamuga venames kunfunige directoru ke ituru memberu as in shareholders nuwata officer so kunfunige misalakan iron koffa hodatane GM nuwata efada mi decision making power onna nuwata controlling power onna farade efada officeru e kunfunyege namuga korikankamma farwadi gotun zimma ufulanje hene emma it's not just now limited to directors then anani halataga kunfunige corporate veil naga e kunfunige directoruna memberuna officerun kunfunige kankama farwadi gotun zimma wanje hene kan kota kande elidan then halettakuge terega mehemeneni kunfunige verinaki wakin harakatere faratta kanu kunfunige amaltakaki makara hilatun koffawa nurangalu amaltaka kawuma eku e amaltu forumasha zimmaen badiyawuma kunfuni benu koffawu kunfuni nohaggum benu kurmuge sababa sida gotega eves farataka gellume libifawuma ekamuge ganuni zimmaen badiyawumataka kunfuniga shahsiyatu benun kuru then kunfunige corporate wel negumuga tirigawa kankamaki makara hilatuge amale kaman nuwata nurangalu amalegi gotuga kota belevidane makara hilatuge amale kamuga belevidane kame kuru kunfunige muda najais gotuga benun kuru e amalu hingi farata nuwata ehen farataka sida gotu nuwata nu sida gotu fada elibe gota kastuga kunfunige kanuni shahsiyatuge benu nahamu gotuga hifuma ekamuge sababun kunfunige maslahata unikamen aswavu adi kunfunige darani adanu kore wara hissataka fada pahannimu mifada halatakaki mi mi shaviyanige dashu makara hamalde makara hiletun koffa nurangalu amal takek gamma belevidan mi madaga bayan kora gotuge matin kotan hushalma kunfunige ewagotek gatibi director una member una officer faradi gotu ekuga nuwata wakin එවස් ගයිදකොරු මැන්නැති කුම්ෆුන්නිගේ අමලක සිමාවන් ජෙහනකම කෝට කණ්ඩේලිදන් එහෙම හමේකනි එබ්බයකු සිම්මාකුරුම්මබුර හම එක්කුවකි නුවත වකිවකින්වස් හම ඩිරෙක්ටරු මෙම්බරු නුවත ඔෆිසරුම් එ අමල හිංගි ෆරඇත්තක සිම්මාකුරුමුගේ සිම්මාවන් ජෙහනකම කෝට කණ්ඩේලිදාන්න then mi madaga raga bayan kura gotu matin kunfunige director na member na officer na fardi gotu ehuga nota waki zimma wanje hene kama kotun kandala halatuga annaniwe amuluta neruma kota baru libifave e kunfuni uwalamuge amar nota kunfunige kanka kuriyan wetanuga waki gotaka inguma kandala amuru kuru so mi haru mi kunfunya be ganunu mi alang mi ගානූනුගේ දශුම් වර ඩීටේල් කොන් එබයින් කොපරේට් වෙල් නෙකුම ක්ලෝස් එෆද හාලතක මේ කුරවෙන ඉතුර කුරවෙන කංකම් කුරීගේ ගානූනු ගමින්නනි වඩ ලිමිටඩ් කො කුම්ෆුනිගේ කුම්ෆුනි ගානු ශාසයත් නම්බොද්ග බේනුම් කොෆිය කුම්ෆුනිගේ ඩිරෙක්ටරුම් සිම්මදාඩු කුරවෙන කමරන වෙස් මිහාරු එහබුර කොඩ තක්සිල් කොම් මේ ඇස් මේ වනි corporate way lift kurane haletta. Then kunfunya behe ganunu me they have stay with wana haru a ganunu ka huri bae updates tangarun kyal den wat kala screen share change. Me alanga kunfunya behe ganunu ga in me haru recognize kore hataru Pattarege Kumfuni couldn't think was the Kumfunya recognize a private limited company, public limited company, state owned company. Then it would have been had a local authority company at the foreign investment company. Private limited company yaki hama private kumfunita mi armana generally my friend and then public limited companies yaki ni dira go PML mi fada kumfunita. Then a to a state owned company yaki was me sarukaru hissa me wa kumfunita. Then local authority company yaki mi lamar kazi osolo hinguma mi if farata kalamar kazi local authorities mi haru ufette kunfunita ves mi haru recognize kure kunfunya behe kamanunuga. Then the foreign investment company ei beruge hissa darung mi rajang invest kurang mi hada kunfunita kaki foreign investment companies. Then Kuriga Kumfunya Beheganuga, there was it required a minimum of 2 shareholders for the formation of a company. Now, as Mihar Kuring and Suala Hafavagota, Mihar single shareholder companies can be formed. There are certain special provisions and exemptions on how general meetings, director meetings, and affairs of single shareholder companies are conducted because it's different from the um, you know multiple shareholding companies how it is run. Um, Me Companies Act 2023 also allows for one director to be on the board of directors, removing the requirement for a minimum of 2 directors. So previously, the Companies Act required 2 directors to be on the board of directors. But even now, even before, there should be at least one director who must be resident. So in the case there's one director on the board, that director must be resident in Maldives. So resident means it could either be a Maldivian or someone who has, a visa or has a residency visa in Maldives. The new requirement There's also a new requirement for companies to maintain register of directors, shareholders, charge over shares, and significant beneficial owners of the company. The new Companies Act also details the legal rights and powers and obligations of the shareholders of the company. So if it also recognizes the legal rights and obligations of directors of the company in section 128 to 135 of the Companies Act. So I will just take a look at these from the act itself before we conclude. So there's previously it was not this detail, but me har tangora detail ka kumfunige member onge hagutaka barutaka zimma kumfunya behe kanonu gawani me include kofa gotun kumfunige member ge kanoni zimmage gotuga me bayan korani me madagi shavenya hilafnu wa gotuge matin kumfunige evs member ko hame kani sababattaka kumfunyage evs kanonu iltizamaka zimma wa kanu chehene because kumfunya ki waki kanoni shahsevima kumfunige memberun naki separate legal entity doctrine ge dashum waki baevima කුම්ෆුනීගේ එවස් ගානු නිල්තිසාමක සිම්මාවා කන්නු ජෙහෙනි කම මේ බයන් කරනි එන් කුම්ෆුනීගේ එවස් මෙම්බර් කුම්ෆුනිය සිම්මාවා ජෙහෙනි එමෙම්බර් හු ගණෆාවා නුවත නකාෆාවා එවස් හිස්සායක දක්කන් ජෙහෙ එවස් පෑසාය කුම්ෆුනිය නුදක්කාව වෙජ්ජ නම ඒ අද දක කුම්ෆුනීගේ දුස්තූරුගා සරීහ නස්සුන් කණ්ඩාලෆාවා ගොතුගේ මත්ති කුම්ෆුනීගේ දුස්තූරකි ගොරින් වෙස් ෆෙෂීරු කුම්ෆුනී හිංගුම මේ අනේ Kumfunige constitution, which includes the Articles of Association and the Memorandum of Association. The Miganunga Bayankura Enuves Kotegge Mati. So, me provision get area one and me har misala Kumfunige Kumfunige Garner Shasia to Nahamagatuga Benuko phenomenon the corporate well lift Kura Hala Tekega me Shavia Nigetine get Dashang a Kamuga Sababun Kumfunige memberun Zima Vanje Hitan. Then hama hissa gule gotun evagotun hori memberako zimmabu. Kumfunige eves hissayaka gule gotun ehissaige agu ambura dekkumuge iltizam onna halategga nuwata enuves iltizame onna halategga ehissage agu ambura dekkumuge nuwata enuves iltizame ufulumuge zimma onnani evugutuku ehissaige milku veri faratuge gotuga registry koffava farategashe. Ei iltizam ufanvi iltizam nisbaba hissa e memberako negi taadihu kurin kama veenama vesseve. Hissai registry for oi membering e hissaige kankama golevatu zimmanagan jehene kama me adihashe kame porani. Then madage haga hen goteka bayan kofa veenaves mi ganonege sateka fastora sateka fastora seke van madaga bayan kora gotumatin kufunige hissa ka golegoto iltisa mukurige member ko adanukko එමද්දතකුග බයන් කොරා ගොතුමති හිස්සා තූකොල්ලෆාවරණම නුත කූෆුනින් හිස්සා බුර අතුලාෆාවරණම එහිස්සාකා ගොලගොත ඉල්තිසාම්ත අදා කොරා කුරුමුගේ සිම්මා උන්නානි කුරීගේ මෙම්බරුන්ගේ මච්චෂේ දැන් එහෙම මේ කුම්ෆුනිගේ මෙම්බරුන්ගේ කානූනි සිම්මායගේ ගොත කුම්ෆුඤ්ඤා බෙහෙ කානූනුග මේ බයන් කොරණි කුම්ෆුන් අනේ විමාතාගේ ශාවියනික මේ බයන් කොරා හාලත්තකුගේ ඉතුරක කුම්ෆුනීගේ එවස් ඉල්තිසාමක කුම්ෆුනීගේ මෙම්බරුන් සිම්මා වහගන්නු ජෙහෙනකම දැන් කුම්ෆුනීගේ ඩිරෙක්ටරුන්ගේ සිම්මාතක බලායිරු komme kumfunyaves mi directorunge baara kanuni zimmae masudiyatu mi baga mi bayan korani komme kumfunyaves hingamani mi kanunuga kumfunige mi kanunai kumfunige dustura ekkowa gotimati kumfunige directorun nimmuma ekkowa gotige mate hemema kumfunya hinguma meba ade tinkame e mi kanun as in kumfunya behe kanun then Kumfunige Dusture, Kumfunige Constitution, including the Articles of Association and the Memorandum of Association, Kumfunige Memberung, Soeko Nimafava Dusture. Then Ege Itura Kumfunige Directorung, Nimma Gotaka Kumfunime Hingeni. Then Kumfunige Directorung, එමගේ බාර්ථක සිම්මාතන් අදා කොරම්මානි එයා حالتකුග සබබුවැඩි ඉන්සානකු so reasonable man එෆද මසූලියත අදා කොරමුග පයන් කුරාණ ෆද හුනරා ෆරුදා තෙරිකම් බහට්ටාගෙන්නෙව එම reasonable man නෙන් එකම් මසූලියත අදා කොරුම අදා කුරාණ ෆරුවා තෙරිකමා හුනරු ටැලන්ට් නොද ස්කිල් බහට්ටන් ජෙහෙනකම මේ කුෆුඤ්ඤා බෙහෙ කාණුගේ සතේක 30 වන මාතා ගම්මි පයන් කුරණි දැන් කුම්ෆුණිගේ ඩිරෙක්ටරුන් එෆරාත්තක්කුගේ මස්සුලියත් අදා කොරමුගා හන්නනිවි ෆතෑන් අමල් කුරමන් දැන් කුම්ෆුණි අබෙහෙ කානුනිගේ රිකයි කුරේ වකි මේ කැරෙක්ටර් වකි ගොත්තකේ ෆොලෝ කුරන්ජෙහෙ වකි ඩියුටිස් තකේ මේ බයන් කුරණි කුරීගේ කුම්ෆුණි අබෙහෙ කානුනිගේ මෙහා ඩීටේල් කොෂේ ඩිරෙක්ටරුන්ගේ මස්සුලියත් අදා කුරන්න ගොයි බයන් කොෆෙනොය නමස් මෙහාරුගේ කුම්ෆුණි අබෙහෙ කානුන් similar to the Companies Act of UK with England and Wales me eba bayan kore waki goittaken amal kuranje egoton jumlako kumfurnige emeha memberunge labaya manfaataka heyoniyata ako kumfurnyan emme fahada huri kotuka kumfurni kureruma masekke kuna so generally kumfun ane you England and Wales can eba bayan kore directors must act in the best interest of the company. So this is what it means. Me kumfunige emme ha memberuge labesha mamfaitaka heoniyata kumfuni emme fahda hori gotuga kumfuni kureruma maseke kuro. Then eves faratege nufuzun ekkibawe hure mustagilu kama ko nimmuta nimmu. Maslahatu fushuarafa de emme ha kankama duru helibu. Timana farate kon eves manfa libiganike nu. කුම්ෆුණිගේ ފަރާތަށް ކުރާ އެއްވެސް މުޢާމަލާތެއްގައި އަމިއްލަ މަސްލަހަތެއް ވާނަމަ އެކަން ހާމަކުރަ this point relates to conflict of interest so މިހާރު ކުންފުނީން އެންޓަރވާ ޓްރާންޒެކްޝަން އެކެ ސަބަބުން އެ ޑިރެކްޓަރަކަށް އަމިއްލަ މަސްލަހަތަށް ރާނެ އަސަރު ކުރާނަ ނުވަތަ މި އިތުރު މި ފައިދާއެ ވާނަމ ނަތަ މަންފައެ ވާނަމަ އެކަމެއް ޖެހޭނެ ބޯޑަށް އަންގާފަ އެކަމާމެދު ގޮތެއް ނިންމަން before they can proceed with such transaction. Then gulun hori emmeha farattakun not stakeholderunge meduga tafatu kurumeneti hama kamayako amal kurun hama kurun muhimmu malumat sahha kamayako ekashigenwa avasmenegga hama kurun kumfunige memberunna jawabudarivun kumfunna gole emmeha nimmuntake nimmumuga amal kuranje ahlagi adi suluki mingada riaya kurun emema me directors duties ge gotuga miwa gotu kumfunya behe karannuga recognize koffa huri kantatta then also kuringe karannuga me kumfunige directorun me waki kurevene haletta kaki hama kumfuning decide kurave kankan then miharu hama kumfunya behe karannuga eba bayan kure specific haletta kumfunige directorun waki kurevene then directorunge magamu කුම්ෆුණිගේ ඩිරෙක්ටර්ನ ವಕಿಕೊರಮುಗ ಅಮಲು ಕೊರಮಾಣಿ කුම්ෆුණಿಗೆ ಹಿಂಗಾಗವಾದುಗ ಕಂಡಳಿಫಾವ ಗೊತ್ತುಗೆ ಮಾತಿನ್ನೆ එහෙම කුම්ෆුණිಗೆ ಮೀ ದುಸ್ತೂರುಗ ಮೀ ನುವತ ಹಿಂಗಾಗವಾದ as an articles of association ಕೊಣ್ಣ ಗೊತ್ತ කුම්ෆුණಿಗೆ ಮೆಂಬರುನ್ ವಕಿಕೊರೆವೆನೆ ಕಮ ಮೀ ಬಯಾನ್ ಕೊರೆ ದೆ ಸತೇಕ ಫನರವಣ ಮಾತಾಗ ಎಬ ಬಯಾಂಕೂರೆ ಡಿರೆಕ್ಟರುಂಗೆ ಷರತ್ತುತಕೆ එහෙම ಡಿರೆಕ್ಟರುಂಗೆ ಕಿಬಾಗ ಮಿಹಾರು ಹುಣ್ಣಂಜೆ ಸ್ಪೆಸಿಫಿಕ್ ಷರತ್ತುತಕೆ ಎಬ ಹುಡೆ ಕಾನೂನು ಮೀ ಕಾನೂನುಗ ಬಯಾಂಕೊಫ ಎಗೊತುಂ ಫುಡತಮ ಕಮಕ ಮೀ ಶಾವಿಯಣಿ ಮೀ ಸತೆಕ್ ಫಣರ ಮಾದಾಗ ಶಾವಿಯಣಿಗ ಡಿಸ್ಕ್ವಾಲಿಫೈ ಕುರೆ ಫನುವಾ umurun ashara har furifawa farataka mi director anje den shaviyani gammi mi bayan kora halataka ki annani be halatun kura halate gawa mihako e halat medore fawa muddataka kumfunyage director ege gotaga ayyane nukurevene adi kumfunyage director ege gotaga huri farataka ifada halate medore rejenam e mihako director kamun waki maane එහෙම ඒගොතුගේ මතින් මේ හාලතකගේ ඉෆ්ලාස් කුරුමා බෙහේ කානූන එක දශුන් ඉෆ්ලාස් කුරේ ෆැවා ෆරාතේ ඉෆ්ලාස් කුරවුණු තාරිහොන් ෆෙන්ශිගෙන් ෆස් සහරු දුවස් tuwahuge muddatan e farataga director kanu evenekam iflas kurma behe nuwata insolvency behe kanunege dashun iflas kure fawa kumfunyege director nuwata partnership ke partner iflas kure wonu tarihun feshigen fasaharu tuwahuge muddata so kurimini iflas kure fawa farate as in personally iflas kure fawa then nuwata iflas kure fawa kumfunya nuwata partnership egge director nuwata partner kamuga waname sefarades fasaharu tuwahuge muddata director kan moge magama adanu kure vene kamu be bayan korani then දිවරාජයේ ගානොන්නු උගෝබාතුගේ දුයිස්ත බාරවන මාතාග බයංකුර මකරා හේතුගේ පුෂුගෙසි ಜಿನಾಯತುಗೆ ತಿಮ್ಮನ ದರಜಾಗೆ ಕುಶೆ ನುವತ ඒ ගානුගේ දුයිස්ත ෆනරවන මාතාග බයංකුර හිනායාතුගේ කුෂුගේ හියානාතුගේ කුෂුගේ ಜುನಗೆ ಎವ್ವನ ದರಜಾಗೆ ಕುಶೆ ನುವತ ಮನಿ ಲಾಂಡ್ರಿಂಗ್ ಅಬೆಹೆ ಗಾನುನುಗ ಬಯಂಕುರ ಕುಶೆ ಕುರಿಕ ಶರಿಯತ ಸಾಬಿತು ಎಫವಾ ಮೀ ಹಕುಣಮ ಹುಕುಂ ಫಿರಿಹಮ ಕಣಿಮುನು ತಾಣುವತ ಮಾಫು ದೆವನು ತಾ ಫಸ್ಸಹರು ಎಫಾನು ನುನ್ ಎಹೆ ಎಫದ ಹಾಲತೆಗ್ಗವೆಸ್ ಡಿರೆಕ್ಟರ್ ಕಣುವೆ ವೇಣೆ ಕಮಮ್ಮೆ ಬಯಂಕುರನಿ ದೆನ್ ಮಿಗಾನುನುಗೆ ಫಣರನ್ ಬಾಬುಗೆ ತಶನ್ ಡಿರೆಕ್ಟರ್ ಗೊತುಗ ಹುರಿ ಫರತೆನ್ ಅಳ ಎವ್ವೆಸ್ ಫಿಯವಳಿಗೆ ದಶನ್ ಕುರೆವೆ ಜೋಡಿಮಣ ದೆಕ್ಕುಮ ಕಂಡಾಳ ಮುದ್ದತುಗೆ ತೆರೆಗಾಯ ಜೋಡಿಮಣ ಅನು ದಕ್ಕಾತ ಎಂಗಹರ್ ದುಹಗೆ ಮುದ್ದತೆ ಫಾಯ್ತುವೆ ಫೆವಾಣವೆಸ್ ಡಿರೆಕ್ಟರ್ ಕಮುಗೆ ಮಗಾಮಾದಾನು ಕುರೆವೇಣೆ ಕಮಮ್ಮೆ ಬಯಂಕುರನಿ දැන් කුම්ෆුණියගේ ඔඩිටරකු නුවත ලික්විඩේටරකවෙස් කුම්ෆුණියගේ ඩිරෙක්ටර කනුවේ වෙන දැන් එහෙන් කානෝනගේ දශුන් වත එබස්සුමගේ දශුන් කුම්ෆුණියගේ ඩිරෙක්ටරයක ගොතුග පුරු මනා කොෆ්ෆා ෆරාත එෆදා මනා කොෆ්ෆාවා මුද්දතවෙස් ඩිරෙක්ටර කනුවේ වෙන දැන් අරන් කුරේස් දැන් එෆදැන් කුම්ෆුණියග්ගා මේ ඩිරෙක්ටර හුරු මිහාරු ರಂಗಳು mi kungunya behe gaanuneka bayan korana mes e directoraki mi amuko diveraja kamazam verive direwule farate kamuga wanjehene then mewa gota and mi syllabus sing and mi syllabus bala and mi haru mi level key points and highlight kolawani kama and kabulu kureveni de itur swalena marda hama har jawab deven